In July 2014, the Human Rights Council adopted the groundbreaking Resolution 269 for the elaboration of an international legally binding instrument on transnational corporations and other business enterprises with respect to human rights. This resolution represented a milestone. It was indeed the first attempt to regulate business operations at an international scale. It implemented a working group to draft what is to become the new treaty. To date, 4 sessions of the working group have occurred. The first version of the draft was released in July 2018 by its presidency. The process raised great hopes among human rights advocates. However, the first version of the draft raised concerns as to its content, scope, and nature.
Some of the most intense pushback against the Zero draft is its focus on solely on transnational business enterprises as opposed to anything that is domestic, and that sort of limits its effectiveness.
And I think this is highly problematic, and especially to achieve what I believe is the main objective of the treaty, which is to create or to enhance legal liability for business enterprises.
And I think we should understand that this Zero draft does not apply only to transnational corporations. Rather, it applies to all companies which have a transnational character. This is different from saying it applies to only transnational corporations. This is much wider. And I think although it would be ideal if this instrument applies to all business enterprises, but at the same time, the challenges in regulating transnational corporations are very different.
Secondly, the draft was criticized for not following the UN guiding principles. They were uttered by John Ruggie in 2011. They implement the Protect, Respect and Remedy framework for enhancing standards in addressing the risk of adverse impacts on human rights linked to business activity. They set human rights due diligence in a 4-step process. This criticism seems to be a consensus among experts and human rights advocates.
It's not a point of that we need to follow strictly to the letter what the guiding principles on business and human rights says, but we need to start with it. Yeah, we need to start with it, and we need to, the best is perhaps to take it as a starting point and use the steps, broadly the steps that are designed there, because after all, on this issue of human rights in the due diligence, the guiding principles is the only international document that we have. So it is just fair that we really use it and be based on it.
When it comes to mandatory human rights due diligence, I think it would be desirable that the draft follows the UN guiding principles, the 4 steps of the UN guiding principles, and I think it does not do that properly. So I think that is something that should be taken into consideration. Say that if there are some gaps in the 4-step process, the instrument can improve on it. But it should not dilute what we already have.
So in terms of implementing a binding treaty, I've really struggled to see how that could affect change on the ground.
Implementation of international human rights law is a major issue, major challenge, not just in the field of business and human rights, but generally. But then the question is that how do we improve on that, rather than saying that, international human rights law is very weak and that's why we should not evolve the law. Tools that this instrument should use is to use non-state actors who can enforce it. So we have to leverage the power of investors, consumers, civil society actors, human rights defenders, the media and others who can play a role in implementing international law in a different setting.
Lastly, what about businesses' standpoint regarding the treaty process? Several organizations representing the business community attended the negotiating sessions. They produced a joint response to the treaty to clarify their position on it. Overall, they do not support the draft. They argue that it does not align with the UNGPs, that it does not respect national sovereignty, and that it will ultimately harm countries' investments and economic development. However, the rightfulness of these criticisms is questioned by human rights advocates. They instead question the willingness of businesses.
Opponents, of course, they are just dedicated to oppose it for whatever reason, rather than taking proactive steps to explain the problems and how to solve them. I think the purpose, also the main purpose, which is key to understand at the beginning for this kind of treaty, is clear now. You can see it from the flow of the text. It is dedicated to improve, to enhance the capacity or the possibilities or the chances of people affected by operations of business enterprises to have access to justice.
We need binding rules like we need binding rules in other areas. I mean, they will complement the complementary and they will complement the soft or voluntary instrument. I mean, there is this dynamic relationship. And I think it's any mindset of having either only hard or only soft is highly problematic in my opinion.